My name is Severyna Magill. I teach at Jindal Global Law School, and this module is for the E-Pathshala UGC. The module on National Legislative Frameworks will address today the Protection of Women from Domestic Violence Act 2005. This module will introduce the reader to domestic violence as a human rights issue, provisions in human rights law applicable in this context before elaborating on the provisions of the Protection of Women from Domestic Violence Act from 2005. The module will end by identifying some of the weaknesses in implementing the Act and make recommendations for its better implementation. Domestic violence is an important site of gender inequality across the world and is rampant and widespread almost all over India. Women from all socio-economic groups face matrimonial violence. The National Family and Health Survey 3 noted that nationwide about 40% of women have experienced sexual or physical violence after marriage. The status-based discrimination that women are subjected to, as well as patriarchal cultural norms and institutions, entail that a large number of incidents of domestic violence are A. Not understood as problematic and illegal, B. Seldom reported even if identified as problematic, C. Not pursued to their end, perhaps at the intervention of local, familial or community mediators, or due to the invocation of the ideas of honour or other institutional barriers, and D. Are given inadequate and unequal consideration when pursued because law enforcement agencies themselves are products of ideologies and cultures that have normalized gender-based violence and discrimination against women. Domestic violence may range from acts of intimidation or mental emotional abuse to acts of physical violence ranging from simple to grievous hurt to sexual abuse and murder. In this context, it is important to note that under criminal laws, marital rape is still not recognized as an offence. Domestic violence is a violation of human rights that occurs with alarming regularity and has a permanent and even intergenerational impact. The 1993 UN Declaration on the Elimination of Violence Against Women, from now on DVOR, held that violence against women is an obstacle to the achievement of equality, development and peace. It constitutes a violation of the rights and fundamental freedoms of women. It's a manifestation of historically unequal power relationships between men and women, and, while because of such power relations, women in general have been dominated and discriminated against, and certain groups of women, such as members of minorities, refugees, and migrants, are disadvantaged at multiple levels, leaving them especially vulnerable to violence. As the DVOR is a declaration, it only serves to provide useful information on how to conceptualize both violence against women generally and how this may constitute a human rights violation specifically. The Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, is a treaty. It thereby establishes legal obligations upon all states who ratify it. India ratified CEDAW in 1993. Although the Convention lacks a provision explicitly addressing violence against women, it enjoins states party to modify the cultural and social patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority and superiority of either of the sexes, or on stereotyped roles for men and women. Further, it enjoins the state to take all appropriate measures to eliminate discrimination against women in all matters relating to marriage and family relations. These provisions, with their emphasis on modifying the conduct of men to eliminate discrimination against women, can be clearly applied to domestic violence. This is because domestic violence is overwhelmingly perpetrated by men against women, and the impacts may be both physical and psychological. They may sometimes last for the remainder of a woman's natural life and may even result in her premature death. Globally, as many as 38% of murders of women are committed by a male intimate partner. While CEDAW issued its first general recommendation on violence against women in 1989, it was with General Recommendation 19 in 1992 that violence against women and state responsibilities were most clearly articulated. General Recommendation 19 required a holistic approach to different manifestations of violence against women, identifying violence as a form of discrimination and thereby adopting a rights-based approach to respond to it. Violence against women was brought unequivocally into the domain of international human rights law. The recommendation followed the UN Decade for Women, where the most commonly considered form of violence at the international level was family or domestic violence. It is now credited as shaping both opinio juris and state practice to such a large extent that violence against women and obligations to address it are now argued to be customary international law by some people. Domestically, the Constitution of India prohibits discrimination on the grounds of sex and permits special provisions for women and children. These provisions have been interpreted to both allow affirmative action as well as the creation of laws applicable to women's social reality. The Constitution, therefore, recognizes both the role of formal and, importantly, substantive equality in combating discrimination against women. In addition to this, Article 21 recognizes the right to life and personal liberty. Through judicial activism, Article 21 now includes a substantive due process in addition to the formal procedural one. Consequently, it has received an expanded interpretation and now includes the right to life with dignity. Various laws have been enacted to correct gender-based discrimination and have met with limited success. New laws have been enacted and existing laws have also been amended, but the statistics continue to give us a grim reality of the increasing incidence of gender-based violence and, in particular, domestic violence. For the reasons discussed earlier, such as stigma and societal pressure, it is plausible that the data could actually underestimate the phenomena of domestic violence, and yet the numbers, whatever they may be, are in themselves unsettling and alarming. Prior to the enactment of the Protection of Women from Domestic Violence Act in 2005, hereafter the PWDVA, there were several laws in India that punished different forms of domestic violence. These included the Dowry Prohibition Act from 1961, and Indian Penal Code provisions such as Section 498A for cruelty and 304B, dowry death. The PWDVA came into force in 2006 to provide a comprehensive definition of domestic violence and provide various civil remedies and the creation of support structures to aid its implementation and to help effectively resolve the plight of domestic violence survivors. It is a civil law with criminal features supplementing the existing family, property, and criminal provisions, and it recognizes domestic violence as a human rights issue and a serious deterrent to development, which criminal law is unable to address in its entirety. The definition of domestic violence, as per the PWDVA, states, anything that harms or injures or endangers the health, safety, life, limb, or well-being, whether mental or physical, of the aggrieved person, or tends to do so and includes causing physical abuse, sexual abuse, verbal, emotional, or economic abuse, or harasses, harms, injures, or endangers the aggrieved person with a view to coerce her or any other person related to her to meet any unlawful demand for any dowry or other property or valuable security, or C, has the effect of threatening the aggrieved person or any person related to her by any conduct mentioned in Clause A or B or D, and otherwise injures or causes harm, whether physical or mental, to the aggrieved person. In addition to the acts of commission, the law also includes acts of omission and general conduct of a man that harms, injures, or otherwise tends to threaten or endanger the life of a woman. The law also recognizes various ways in which a woman could be abused, including physical, such as beating, kicking, or any other physical act of injury, sexual, including humiliating or degrading sexual acts, economic, including deprivation of basic resources and necessities, and verbal and emotional abuse, including insulting or ridiculing. It also includes coercion and violence in relation to dowry. The PWDVA recognizes a woman's right to reside in a violence-free home and provides emergency remedies in case this is violated. The Supreme Court of India in Velusamy v. Pachamal ruled that this law applies not only to matrimonial relationships, but also to live-in relationships under the rubric of relations akin to marriage. Unlike criminal law, no arrests are made under the law. Instead, it adopts a rehabilitative approach to keep a marriage functioning, but safely, and provides for other remedies, such as the right to reside in a shared household, residence orders, protection orders, compensation and other forms of monetary relief, and the power to grant interim and ex parte orders. While some of the acts and conduct mentioned in the Domestic Violence Act are also punishable under the Indian Penal Code, the civil remedies under this law are easier and faster to access. The Act recognises three important rights, namely, the right to be free from violence, the right to reside in a shared household, and the right to obtain remedies provided by law. To enable access to the remedies, the Act provides that state governments should appoint a protection officer and service provider as per the requirements of the area. Any person with credible information of domestic violence either being committed or likely to be committed may inform the protection officer, who shall then take an appropriate step, such as mentioned in the legislation. Recognising that police stations may also be the sites of distress and violence for many women, many protection officers are based in Mahila Thanas or women police stations. It is hoped that these officers will facilitate access to justice by being more convenient as well as providing more congenial access points to the legal process. The Act, therefore, mandates that both complaints brought to the attention of a police officer, magistrate, or a protection officer are all taken cognizance of. Protection officers and police officers should acquaint the woman of her remedies in criminal law as well as the provisions of the Act. This section discusses the remedies under the Domestic Violence Act. Provisions include right to reside in the shared marital household. The Act recognises the right of every woman in a domestic relationship to a shared household, irrespective of whether she had any title or beneficial interest in it. The provision recognises that in India, the majority of women will, upon marriage, move into their husband's home, and this home is often multi-generational and shared with the husband's family. Such practices result in most women being unlikely to have any legal claim to the property itself. They also have little access to legal documents purporting ownership. Until recently, Hindu women had unequal inheritance laws, and even today, accessing ancestral property remains fraught with barriers. It is known that women own a very small proportion of property, which are mostly akin to benamis, since they are rarely exercising any real control over it. This measure is important, therefore, to ensure that women living in relations are not removed from their houses, thereby compounding their vulnerability. Aggrieved women may seek appropriate legal intervention and retain their residence in case they are thrown out illegally. Protection orders are also provided for. They enable an aggrieved person to apply for a protection order. A court may then direct the perpetrator to immediately stop any act of violence against her or anyone related to her, and any communication with her. This is intended to prevent the respondent from visiting her place of employment. Moreover, the court could also direct the respondent to not undertake any financial transactions to the detriment of the woman. Residence orders are provided whereby a victim may demand a residence order in case she faces the risk of being thrown out of her matrimonial home. The Act not only recognises her right to shared residence, but also provides a remedy in case she loses her shelter. This recognises that for many married women, returning to their ancestral home is not socially possible. Significantly, if a woman feels threatened in staying with her husband, she may either seek his removal from the residence, or the court may direct him to provide her with an alternative. No order can be obtained with respect to the removal of a female from a shared residence under this legislation. Monetary relief is also provided for. A woman who is experiencing domestic violence may seek monetary relief such as medical expenses and loss of earnings and maintenance for herself and any children she may have, or maintenance regarding any loss arising from damages to property. Court, granting such relief, should ensure that it is fair, reasonable, and consistent with her standard of living. The magistrate may award a lump sum of monthly payment of maintenance depending upon the nature and circumstances of the case. As an extraordinary measure, if the respondent fails to make the payment as fixed by the court, it could even ask his employer or debtor to submit the required sum of money to the woman directly. This would then be offset against his wages or the debt. Custody orders are also provided for. A woman who is a victim of domestic violence is entitled to seek custody orders from the court to prevent being separated from her children. Fear of separation from children could dissuade women from reporting or seeking remedies against violence perpetrated upon her. A court is therefore empowered to draw up an arrangement to allow or disallow the respondent to visit the children. The reliefs discussed above can be sought by a survivor of violence at any forum, whether it is a family court, civil court, or even a criminal court, even if a case was initiated before the enactment of this piece of legislation. Interim or ex parte orders are also provided for. Hereby, the Act empowers courts to grant interim reliefs and ex parte orders while a case is still pending. Interim reliefs provide much needed support and security, especially to a victim of violence who is otherwise socially and economically vulnerable. Ex parte orders is another significant procedural relief which allows the court to pass an order in the absence of a party. For example, if someone does not come to court, but the court is satisfied that there is reasonable apprehension of immediate and irreparable injury to the applicant if the order is not granted, and the balance of the convenience also favours the victim. Hence, if a magistrate is satisfied that the application on affidavit makes a prima facie case that the respondent is committing or has committed or is likely to commit domestic violence, an ex parte order could be granted against the respondent on the basis of that affidavit. It is an important provision along with the interim order to ensure that a victim is not prejudiced by the delays of the legal process or due to any dilatory tactics the respondent may resort to. These orders operate for as long as the aggrieved woman wants them to operate for. In case she has received some other relief or if the parties have arrived at a mutually satisfactory arrangement, either party should inform the court about it and the order could be accordingly revoked, modified or cancelled. There could be a reasonable apprehension in the mind of the aggrieved person whether any remedy exists if the respondent continues to violate these orders and continues violence against her. To tackle this, the Act also declares that violations of a court order and continuation of violence would be a non-bailable criminal offence. To tackle this, the Act also declares that violations of a court order and continuance of violence would be a non-bailable criminal offence, attracting a maximum imprisonment for 1 year and a fine of Rs 20,000. The court may arrive at a conclusion on such a matter even if it has only a victim's testimony to rely on without other pieces of evidence. The magistrate may also initiate proceedings under Section 498A of the Indian Penal Code, which provides for stringent punishments in case of matrimonial cruelty, if the alleged facts disclose that such acts were committed. The role of service providers or protection officers is explained here. Protection officers, preferably women, are duty-bound to assist the aggrieved woman in accessing justice under this Act. They are appointed based on the qualifications and conditions prescribed by state governments. They help facilitate a woman's access to court remedies, legal aid, and other support services. They are needed to help her file domestic violence incident reports and ensure their circulation to the competent police station to initiate an investigation. Protection officers are also required to assist courts as well as magistrates in discharging their functions. Non-governmental organisations or NGOs, voluntary associations working for women, can also serve as service providers. They must register themselves with the state government. Service providers and protection officers must assist aggrieved women to get shelter, medical aid, and protection orders whenever required. Of course, they may also proceed on behalf of the aggrieved woman if she consents to it. The magistrate, in the meanwhile, could also recommend for an aggrieved woman, and in some cases both her and the respondents, to go to counselling, or to seek the assistance of a family welfare expert to arrive at a possible reconciliation. If this does not work, the court may then pass an interim order as it may deem fit. The court may then proceed to evaluate all of the arguments to the case, analyse the evidence presented to it, and pronounce a final order. A party, if dissatisfied with any order of the court, could file an appeal with a higher court. It is envisaged that every domestic violence case is treated with requisite urgency and is disposed of in a time-bound manner. Despite the comprehensive provisions under the Protection of Women from Domestic Violence Act, challenges towards its full and effective implementation that mirror the intent and provisions of the Act remain. In 2006, the Supreme Court heard one of the first cases with sections of the Domestic Violence Act being invoked. Taruna Batra and Esa Batra were married in 2000. After their marriage, the couple lived together in a flat with the husband's mother. In 2003, Taruna left the marital home due to an altercation with her husband. When she tried to return, she found that the main entrance had been locked. She therefore filed an injunction with the courts to allow her access. In the meantime, her husband moved to a separate flat and filed for a divorce, but his mother continued to live at the same flat that they had lived in as a married couple. The High Court in Delhi granted Taruna Batra residence in the flat she had lived in as the wife of her husband. It reasoned that mere change of residence by the husband would not shift the matrimonial home from Ashok Vihar, particularly when the husband had filed a divorce petition against his wife. This interpretation is consistent with the provisions of the Domestic Violence Act. It recognises that a shared household as provided for was the marital home where Taruna lived with her partner. It also recognised that the household may belong to the joint family of which the respondent is a member, irrespective of whether the respondent or the aggrieved person has any right, title or interest in the shared household. Further, the High Court recognised that Section 19 states that neither the respondent nor his family members can dispossess a woman from her marital home. When the case came for appeal to the Supreme Court, the judges ruled, if the aforesaid submission is accepted, then it will mean that wherever the husband and wife lived together in the past, that property may become a shared household. It is quite possible that the husband and wife may have lived together in dozens of places, for example, with the husband's father, the husband's paternal grandparents, his maternal grandparents, his uncles, aunts, brothers, sisters, nephews, nieces, or more. If the interpretation canvassed by the learned counsel for the respondent is accepted, all of these houses could potentially fall under the definition of a shared household, and the wife could well insist in living in all of these houses of her husband's relatives merely because she had, at some point, stayed in them with her husband for some time. Such a view would lead to chaos and would be absurd. It is well settled that any interpretation which would lead to absurdity should not be accepted. The Supreme Court's understanding of this definition of shared household is inconsistent with the purpose of the Act generally and Section 19 specifically. The wide definition accorded to a shared household should be read to encompass the variety of potential marital houses a woman may live in. If the court felt that this was too broad a definition and vulnerable to misuse, they could have suggested that a shared home be read to be understood as one marital home. The next section will deal with women being able to access maintenance. In India, women are able to claim maintenance under both the Protection of Women from Domestic Violence Act as well as Section 125 of the Code of Criminal Procedure. Any successful claim for maintenance will usually need a document to prove the income of the woman's husband. If a woman is no longer living with her partner, it is unlikely that she'll have access to such a document, and these may be impossible for her to then locate. As the court can only rule on the evidence presented to it, maintenance orders are typically far less than the amount claimed for, and arguably are less than the amount to be consistent with the standard of living to which the aggrieved person is accustomed. If the evidence produced before the court is not equal, due to the absence of documentation the woman is able to procure, the court's decision will of course therefore reinforce inequality. The Act states that a magistrate may direct the employer or a debtor of the respondent to directly pay the aggrieved person or to deposit with the monies with the court. An additional provision may be added to the Act that if no title deed or salary certificate is presented as part of the maintenance claim, the court must subpoena the said document or, in the case of a cash-in-hand employee, a certified statement from the employer regarding the respondent's income. Such a measure may play a key role in equalizing the playing field when cases go to court. In recent years, there have been many measures to push matrimonial cases towards mediation. Although mediation is affordable and less adversarial, it is also problematic. Mediation centres are unable to enforce certain provisions of the Act and lack a centralised record-keeping mechanism. This makes it hard to be able to follow the aspects of the Act which are being encouraged and implemented as part of the agreement and which are not being complied with. Despite the various remedies provided in law to combat domestic violence, the evil continues to take place across the country. If the National Crime Records Bureau statistics are any indicator, every hour sees about one dowry death in India. Lawmakers have enacted more stringent criminal laws as well as more victim-centric and convenient civil remedies that adopt a rehabilitative approach and a protective approach. Information dissemination, awareness generation, and widespread campaigning are needed to work in tandem with laws and judicial orders for any degree of amelioration. Legal literacy also needs to be created not only with respect to informing women of their rights, but also with respect to accessing the legal procedure to seek such remedies that would be most appropriate for their cases and situation. Without these changes across all levels of both law enforcement and legal awareness, the provisions of the Domestic Violence Act may continue to not be effectively either reachable or enforceable at both rural and urban situations. For the provisions of the Domestic Violence Act to be compatible both with constitutional provisions to equality as well as international human rights law commitments, more attention needs to be paid by the government to ensure effective implementation and thus to remedy the unequal position of women within society and free them from disproportionate levels of violence. This module is now complete. Thank you.